It says there's
Yeah.
gonna be a plea.
Well, that's not a plea. I'm trying to get the boss for her to go to rehab. So, yeah, I think at this point, a plea would be premature. I'd like her to try to get some rehab under her belt before I dispose of it.
Well, they have, we do that.
It's not.
That's a term of
It's
probation.
not a probation law. The state hasn't offered probation.
The state has offered probation. Senator Tim with a mandatory jail of 10 days and a $500 fine.
I'm discussing.
Yeah.
They've offered you probation.
Yeah, y'all talk about it outside the presence of 250,000 people.
Sure.
Arlie Weaver. Hey, Ryan. You've got Arlie Weaver, 3 cases.
That's Miss Staub,
Huh?
That's Miss Staub, wasn't it?
Well, Arlie is missed up?
No, that's her case. I'm sorry. Her cases.
It says 3 cases. It says 3 cases defended to plea.
Yeah, well, I mean, it's an NTRP.
Is that what she's gonna do? I don't see it. There's nothing on the pad.
We just could,
Oh, please.
we could plead,
And
we could plead administrative.
Is that what you're gonna do?
I have an updated PSS. Just when she gets out, I'll kind of explain the situation.
25 CR 144 is now called the state of Texas versus Shelby Nicole Celerandi. She is here with Mr. Kindler, her attorney, and the state's attorney does the definitive formal reading of the indictment and arraignment here. We proceed in a summary.
She does, and we made her.
In summary, this indictment alleges in paragraph 1 that on or about January 17th, 2025 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more prior DWI convictions in 2014 out of County Court at Law number 3. You were convicted twice. And paragraphs 1 and 2 constitute the 3rd-degree felony of operating a motor vehicle in a public place while intoxicated. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. You would be fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. You must serve 10 days confinement in the county jail as a condition of probation. Do you understand what the plan is, and is this your agreement that you've reached with the state?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those 2 prior DWIs in 2014, are those true and correct as they are alleged?
Yeah.
And are you pleading true and correct to this voluntarily and because it is true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and passed.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 made it part of the record without objection. And anything further, I'm going to follow this agreement. I will find then that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here, which supports your guilty plea, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You were placed on regular probation for 10 years. You will be fined $500. There will be terms and conditions of probation, normal and customary for DWI type cases. You must serve 10 days confinement in the county jail. When can you begin that? Immediately?
Yes, sir.
And probation officer will prepare the probation order.
Let her know they may not.
There will be other conditions, including completing a DWI intervention class. That's good. You must have, as you probably heard from the previous case, an interlock device in any motor vehicle you operate
Yes,
that you have to blow in. It has to, you have to pass the test or else the ignition will not start the vehicle.
yes, sir. I have one right now.
Okay, we'll follow those terms and begin your probation successfully, okay?
Thank you, sir.
Let's see, we've got 1, 2, she's on 3 probation.
Yes.
Correct, Your Honor.
Okay, I don't see a new indictment. These are just 3 probations where motions to revoke probation have been filed.
Correct, Your Honor.
First amended motions to revoke probation, by the way, all filed in each of these 3 cases on March 24th, 2025. Clause numbers 23 CR 2129, 24 CR 37, and 24 CR 2001 are each called the State of Texas versus Arlie Champagne Weaver. That's you.
Yes, sir.
Present with your attorney, Mr. Kimmler, and the state's attorney. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
She does when they
Raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Well, there's some similarity here on 23 CR 2129 and 24 CR 37. In summary, each of these first amended motions to revoke unadjudicated probation in these 2 cases similarly state that on February 5th, 2024, in this criminal district court, you were placed on 5 years deferred or unadjudicated probation for the state jail felonies of theft in 2129 and unauthorized use of a motor vehicle in 24 CR 37. Are those allegations true and correct as they are alleged now?
Yes, sir.
You've got 8 violations. What are we proceeding on? Did y'all talk about?
We haven't touched it. I would just go through the she can have pleas are true or not true.
Yeah.
That's
So what?
well, that just if you just read someone out there and she can have pleas.
Okay. She hasn't entered any pleas prior to this, correct?
I believe that she had on 1, 2, and 3 because we held it in abeyance in October of 2024 to place her on the new probation in 24-2001.
Actually, there are no findings on any of these motions to revoke probation. Okay. All right, so let's take them up. 1. States you failed to report to the Jefferson County Probation Office for the months of April, May, June, and July of 2024. And that is similarly alleged in each of these 2 cases, 23 CR 2129 and 24 CR 37. And that was in violation of your probation order. Is that allegation true and correct in each of these cases?
Yes, sir.
Are you pleading true and correct to that voluntarily and because those allegations are true as they are alleged?
Yeah.
You understand that a violation proven by a preponderance of the evidence or greater of 1 or more violations of probation, that is enough to grant the motions to revoke probation. Probation can be revoked and you can be sentenced up to the full range of punishment in each of these cases, which are state jail felonies, not enhanced. So you're looking at, in each of these two cases, if your probation is revoked and you're sentenced, you're looking at no less than 180 days up to 2 years in the state jail. In each case, knowing that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yep.
Happen to these new substantive offenses, and looks like it's numbers 4 and 5.
Which,
Assault, family violence, December 21st, 2024. Illegal possession of a controlled substance, February 17th of this year.
is that in the Orange County?
I didn't say.
It says in Jefferson County. That is not her Orange County offense. It's a Jefferson County
Yeah,
offense.
it is Jefferson County.
The assault was refused from our office. The possession is still waiting for drug results.
Okay. And let's go number 2. This alleges in each case, this violation that you failed to provide verification of performing community service hours as required in each of these 2 cases. Is that allegation true? Completely true to that voluntarily and because it is true in each case. Understanding that that also has the same consequences as what we talked about in your plea of true to allegations number 1 in each case. Let's hold all of that and go to this third one, 24 CR 2001. And again, she waives a formal reading of this motion. We can proceed in summary.
She does, Your Honor.
This one was more recently filed on March 24th of 2025. And again, this states that on October 28th of 2024, you were placed on 5 years deferred or unadjudicated probation for theft of service, a state jail felony. Is that true? And allegations 3 and 4 allege that you failed to report to the Jefferson County Probation Office for the months of November and December of 2024 and January of 2025 in violation of condition 4 of your deferred adjudication order in this case. And allegation 4, you failed to provide verification of performing community service hours as required in that case. Or allegations 3 and 4 in this case number 24 CR 2001. True and correct as they are alleged, and are you pleading true and correct to those voluntarily and because they are true?
Sure.
Yes.
Find you're pleading true voluntarily and you admit that they are true as alleged. All right. Are there agreements on this?
No, Your Honor. It is to
Go
the
ahead.
court. She was bench warranted over here from Orange County. Judge Parkhurst in the 260th court has sentenced her to probation and ISF on new, was it
Burglary of habitation.
Okay, was it old?
From that all these crimes are committed.
There was an older burglary and a habitation case. And so she had these motions to revoke pending, so she was brought over here. She's 5 months pregnant, and it's my understanding, of course, I'm not an expert on these matters, at least on the female end, but that she has a high risk pregnancy. Again, I'm not an expert, but that's what it's been related to me. And in any case, whether it's a high risk or not, ISF won't take her. And so I'm going to have to get with the 260th of Judge Parkhurst to see how he's going to proceed on
How
that.
many children do you have
One.
already?
Yes.
This will be your second?
Yes, sir.
How old is your other child?
Southern.
Ma'am?
Southern.
So I don't think that ISF or SAP is an option if she's continued on probation. Again, my suggestion would be, I guess, to get an updated pre-sentence report so the court can be aware of what her current situation is and how she's
On
obstacles that she's had while on probation before you determine whether
On- these cases, is there any restitution?
No, Your Honor.
No? On
Not that I believe.
either?
I don't believe so.
I think she would benefit from inpatient rehabilitation. I think you would agree with that, is that right?
Yes.
Have you spoken to Franklin House or have you?
Yeah.
Yes, sir. I was there before, the day before I went to court in Orange County.
Damn.
And I've been in jail since then.
So you put yourself in the rehab?
I'm sorry, Your Honor, she was $250 restitution in 2129.
You able to pay that?
I would think her family can be able to pay that, Your Honor. I'll represent to the court.
When?
They hear anybody? Would you be able to pay $250 restitution?
Excuse me, Your
There's
Honor.
also other restitution.
There's another restitution. The cause number 2001. The amount of $3,200.43. So she has 3 cases.
I understand. Two, the first 2 were when she was placed on probation on February 5th, and the third one when she was placed on probation on October 28th
Yes,
of 2024.
it's not written in that order, so I don't know. I don't have the old case written.
To reset it for sentencing, see what,
No, let's see what she has in accrued time right now, and I've got.
well, I know the court's out of that restitution.
I know. And they're gonna, her family can pay that first restitution. What I want to do is dispose of these 2
I see.
and then, keep her on,
I understand. I see where you're going.
Looks like our warrants were cleared pretty quickly, so she was in other places, but our warrants weren't.
she's got 165. So you see, you see what I'm going to do.
Yes, I understand.
All right. But the restitution has to be paid or I'm going to undo it by the end of the day.
Up to 250 or?
Yeah, the 250.
250.
Yeah, he's going to tell you how to do it. Yes, ma'am. And we'll help you navigate through this so it can get done. Because the court has a plan here to try to, whittle down these problems. Okay. All right. Anything else to add?
No, no.
Okay. Let's take up 23 CR 2129 and 24 CR 37. The court finds in each of these 2 cases that you have pleaded true in this first amended motion to revoke unadjudicated probation in each case voluntarily, knowingly, intelligently. 2, allegations 1 and 2 of the motions failing to report and failing to provide verification of performing community service hours. And you have admitted that voluntarily, knowingly, intelligently, and understanding and appreciating the consequences of pleading truth to those. That is enough to grant these first amended motions to revoke unadjudicated probation by a preponderance of the evidence or greater. And the court grants these first amended motions to revoke unadjudicated probation, and your deferred or unadjudicated probation is hereby revoked by this action. In these cases, on February 5th, 2024, in each of these 2 cases, you pleaded guilty to theft of property, a state jail felony in 2129, and unauthorized use of a motor vehicle in 24 CR 37. You made those pleas of guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting the guilty pleas from State's Exhibit 1 admitting in each of those cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in those 2 cases based upon these violations of probation. And you are hereby sentenced to confinement in the state jail for 180 days. That's the minimum you can get. You will be given credit for 165 so far. So you see, you've got like 2 more weeks that you have to finish out the sentence. And restitution in the amount of, was it 200? What was the amount?
$250.
$250 is ordered to be paid in the judgment, which needs to be paid on or before the end of the day so that she can be released when she finished, as soon as she can finish these 180 days. That is in the amount of $250 to the complainant in 23 CR 2129 as her name is written in this indictment. Please get with the family members so that they get the name correct when they submit it for restitution. They send it to the probation office?
Yes, sir.
Yeah, you go to the probation office, which is not far, you know, a block or so from here.
I'll explain it to you.
And there's a form a form of payment that they take, and we'll do that. We'll accept that. That resolves those two cases. On this motion to revoke unadjudicated probation in 24 CR 2001, the defendant has pleaded true to allegations 3 and 4 of this motion to revoke probation voluntarily, knowingly, intelligently, and that is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. And these are allegations of failing to report to the probation as required and failing to provide verification of performing community service hours. Again, the court finds that is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, and you are hereby sentenced to confinement in the state jail for a term of 1 year. That is suspended. You were placed on regular probation for 2 years. There will be terms and conditions of probation that you need to follow so you can get released off of that early. But we're doing this because you are going to be released here on this one. You got to just serve 15 more days on the other two to satisfy those two by law. Then you'll be released, but you'll be on probation on this. And the key thing is you got to report or else you're not on probation. You have to pay the restitution back. Quicker you pay the restitution back, get you out there, get you to get an income, be responsible, fixing the messes. We all make messes. We all make mistakes. We have to fix them responsibly. That's the test for character purposes. We're helping you do your best and the best you can be. Do you understand where we are on this?
Yes, sir.
Okay. So, but that restitution is owed in an amount of $2,500. Did I say 2,000 or 3,000?
It's 3, Your Honor.
$3,500. But you got to get that done before the end of probation. And the quicker you get it done, the quicker that's the key to this case. When you pay restitution back, I consider releasing you early.
Yes. Thank you.
Yes, ma'am. Okay. Everybody understand where we are on this?
Yes, sir.
Okay. Any questions, ma'am?
No,
All
sir.
right. Good luck to you.
Thank you.
Good luck. There isn't any suggestion here that these reports are doctored up, but there are 4 separate reports which show alcohol in the defendant's system. That's what these reports represent, which concern the board that these scram reports reflect those series of tests.
I would ask.
That's back in, what was the most recent test failure was February 11, right?
Right, Your Honor. And then he had a confirmed tamper on (2/27 of 2025) was the latest.
You're going to present evidence to support that one too?
Yes, Your Honor.
Here. Okay, when are you able to be ready for that?
I am able to be ready for that as early as Monday.
And these?
As early as Monday.
Oh,
Again, Judge, I would like to have sufficient time. If I could have a week after I receive the requested documents that I'm entitled to their file, to look at.
you're entitled to discovery under the law.
Right. And I just need time to go through it and then, so if I could have a week after I receive the documents, Judge, I will be ready.
Okay. Here's what the court's going to do, though. This is enough evidence to me. This is sufficient information for me to modify terms and conditions of bond. You're not going to operate a motor vehicle.
He does not have a car. He is not operating. Family member is, had brought him back and forth. You don't even have a license, do you?
No, sir.
See, but all of that I understand, but the problem is if these are true, that indicate that he's using alcohol, he's testing positive for alcohol. Point is how do we prevent him on other than his word? I don't drive and I'm not going to drive. How do we prevent him from jumping in a vehicle? And the second time he commits intoxication manslaughter, it'll be shame on me. Not on him.
Since he's made bond, Judge, I mean, besides that, he's complied.
This is everything.
He contests those.
And and he can say, I don't drive, but how do you prevent somebody? How do you know that they are? Unless you're standing with them all day long. You don't know. It's just your word and your promise. But here, this indicates that you are not good for your promise if it's admitted, if it can be admitted. And that's all we have is your word. I don't have any other physical abilities to keep you from driving unless I throw you in jail, which I'm considering doing if this test positive, because I can't control your actions if you don't follow the rules. I can't prevent you. No one can unless you are detained, because you can jump in a vehicle. And we're going to do what we can to prevent that. The method that we've been using here, these scram devices, if these are admitted and properly, then that's going to be evidence that this court, which is enough evidence for this court to take some action.
Understood.
But I don't want anything bad happening in the meantime.
Well, Judge, he is still complying with the rules of the court in reference.
You mean like this having, like using the
Going back and
like
forth?
not using alcohol?
No, going back and forth to wherever he has to report to the scram, to give or change out the patch. And that is our position is that he has not ever been told that he's been tampering with anything, or that there were ever any problems with the people that he's communicating with.
Find out what the basis is. So
But he has timely reported to change out. He's complied with everything. As I said, he has not, and yes, you can walk outside and jump in a car and whatever, but he has, to my recollection, I represent to the court that he hasn't, but there have been no problems, but we can test those. And the person that we subpoenaed, Judge, and I guess I'm gonna have to ask the clerk to maybe, so we can issue it, advised him that it wasn't his fault or there was a problem with it. It was environmental. And I think that's an issue. And I have, it is in my, subpoena that it should be in the court file. I formally requested a subpoena.
And you provided that information to the state?
Oh,
Uh, and who is that person?
It's in the subpoena.
Who, I mean, what's
Keep your subpoenas until they're actually served. They're not part of court record.
No, but you had to fill out what we sent it down to you.
I don't keep a copy. You get the originals back.
I have, okay. The only information I can see here is the state's exhibit 1, that's part of this record, but it's still, it's a product of the Scram Systems non-compliance report. Those series.
And I show you, this is what I filed with the court judge. And it's a Mr. Simonette, Nick Simonette.
Okay, this was to be here on May 14th.
And that was the last hearing.
Okay,
It was May 14th.
and
And so we,
it's,
To get them.
but it just says Recovery Healthcare Corporation.
right, but in the bottom, I requested not only him, but to deliver his file, Mr. Hall.
Well, but the court's orders are what they are. You can't operate a motor vehicle until further orders of the court. And you have to have an interlock device in any vehicle you attempt to operate. You understand?
yes,
So you got kind of two parts that don't operate. And if you even tried, you have to have an interlock device. And if you didn't, that'd be a second ground that would be a mistake. That would result in a, if this court found out about that, your bond would be revoked if there's truth to that. And you would just sit this one out in jail until we could resolve
Have
it.
you operated or tried to operate a motor vehicle?
No, sir.
But I don't, but once again, you're charged with irresponsibility in the operation of a motor vehicle by intoxication. This isn't going to happen on this. It's not going to happen a second time on this court's warrant. So you cannot operate any motor vehicle unless you have an interlock device. That's a condition of bond. Do you understand?
Yes, sir.
And you don't have to worry about it if you don't operate a motor vehicle.
I do not.
The other thing is that still, the Scram devices, we need to resolve that matter because this court trusts the Scram device. As long as it's proven, well, there's no reason not to. My experience has been that they have been reliable. All right. What are we going to, what are we setting this for
You can
next?
just give, it can't be Monday, Judge, but if we could give them, so
How much time?
I just need his reports for a couple of days to,
As soon as the court can send it.
2 weeks.
that's
2
fine.
weeks, please. Thank you.
And if the state gets a copy of their report, through which I'm entitled to, through their, we guess it's gonna be claimed, okay, an expert,
Yeah.
you provided a copy.
All right. Sure. Let's get to the truth.
That's all I need.
What do you want?
Do you
Facts.
want to test them today?
Yeah, let's just do it just to be on the safe side.
I'll go take it out, go on over there, I'll wait.
All right, Rod Kimbler, who do you have?
Mr. Court, Randy, Your Honor.
So Randy, come on up. Two cases I have, Darren Patterson with Langston Adams. Is he going to be here?
I haven't seen Mr. Adams.
Here. He's been a whole over in this.
Oh, no, that wasn't Langston.
I have Denise Vadrina.
No.
She's here, Judge. That's a review on testimony and all.
Okay, I will take her next after this.
You not have last?
I don't have,
Okay, I wasn't sure on anybody. To be sure what was happening today.
At the conclusion of these pleas, there will be one allocution, Judge.
these were add-ons?
Yes, sir.
Okay.
These are,
I didn't
Mr.
recognize his name.
Mr. Perkins is on Monday's trial docket.
Not anymore then.
Correct, Judge.
We're going to call two cases, cause numbers 22-39766 and 22-39767. the state of Texas versus, is it Cadrain or Cadron? How do you pronounce your first name? Cadron
Yes, sir.
Perkins. And you are here with your attorney, Mr. Reynolds, and the state's attorney. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
He does, and you
Be
make.
pleading to both?
Yeah, that's correct, Judge. Same amount of time to run concurrent.
In summary, these two cases, and we'll take them up together because they are similarly alleging the first degree felonies of murder in each case. And these state in 39766 on or about January 30th, 2022. And in 22-39767 on or about January 1st, 2022, both alleging in Jefferson County, Texas, that you committed the first degree felonies of murder by shooting the complainants or the victims in each case with a deadly weapon, namely a firearm. There is a second allegation of a prior conviction of robbery. Are we using that?
No, there's no need, Judge.
Okay. Do you understand, sir, what you're charged with in each of these cases?
Yes, sir.
These are first degree felonies, which means you face a term of life imprisonment if convicted, or any term not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached in your cases where you would be pleading guilty in each case, found guilty in each case, sentenced to 55 years imprisonment to run concurrently with each case. Is that your understanding of the agreement?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. I show you in each case what's marked as State's Exhibit 1. Did you sign those documents
Yes, sir.
voluntarily, knowingly, intelligently?
Yes, sir.
Did you discuss them with your attorney, and are the contents of these documents, State's Exhibit 1, all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each of these cases
No objection.
without objection admitted. Among other things, these state that you are mentally competent to enter your guilty pleas. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you, or you've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. We're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is all of that true and correct?
Yes, sir.
State's Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence reports are waived.
So wait.
Anything else to add by either party? I'm going to follow these agreements.
Sorry, Mr. Thomas.
The only
And
thing
fine.
is,
You, in each of these cases, you are pleading guilty, sir, voluntarily, knowingly, intelligently, to these allegations of the first degree felonies of murder in each case. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of these two first degree felonies of murder. I hereby find you guilty beyond a reasonable doubt of these first degree felonies of murders in each case. And I am following the agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 55 years on each case to run concurrently. There will be an affirmative finding in the judgments that a deadly weapon, namely a firearm, was used in the commission of these offenses. Do you understand, sir, what has happened today?
Yes, sir.
Anything else from the state? Is there anything?
we have an allocution from the victim's family on 39766, Judge.
All right. Go ahead.
Judge, he is in administrative segregation because he was contacting witnesses. And I think since that's no longer an issue, he's asking that the jail staff be allowed to determine where he stays instead of the court.
That's an accurate statement as to why he was moved into isolation. We had proven to the court that there were some threats against one of the witnesses that testified. Since we're not moving forward with a trial, I have no objections to the jail making administrative changes.
It is allowed, based upon no objection from the state. What do you have?
I have some family, Judge. I didn't know where you wanted to situate.
Okay, the defendant can be seated right here in the witness chair. Thank you.
What did we mention?
Plain state.
Plain
But
state.
they said my release date was the second, the officer that brought me in.
Right.
But I was released from the second from Plain state.
Okay, so your release, thanks.
Okay, cause number 19-33599, the state of Texas versus Alexis Dixon. That's you. And you were here with respect to your attorney and the state's attorney. What we have most recently is a third amended motion to revoke a probation. That's seldom seen here, a third amended, but nonetheless, it can happen. Are the parties ready to proceed here? Does the defendant waive a formal reading of this, and can we proceed by summary?
We're ready, Your Honor, and we can proceed by summary.
Please raise your right hand, ma'am. Do you solemnly swear or affirm any statements that you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, lower your hand. There's no agreement on this?
No, Your Honor, we're leaving it to discretion.
All right. This third amended motion to revoke probation in summary, ma'am, states that on June 2nd, 2021, you were sentenced to 10 years in prison, probated for 10 years for the state jail felony of theft. Now that is a higher than state jail felony punishment that you were placed on. You must have had prior convictions. I don't even have to look. I'll bet you pleaded true to prior convictions. Yes, I'm looking at the indictment. You pleaded true to paragraphs 2, 3, and 4, which were 2017 convictions out of Shelby County, Texas, for theft, burglary of a building and controlled substance. What happened was that state jail felony, the punishment then of the state jail felony became enhanced as though it were a third degree felony. So you were looking at up to 10 years imprisonment. Thus, you were sentenced to 10 years in prison, probated for 10 years. Have we had hearings on this before?
I mean, Your Honor, we need to.
We're just going to go to the third amended?
Well, I can explain kind of what happened.
Okay, yeah,
Are we on YouTube?
yeah, we are, as much as we can be. Hold on.
Could you?
To build coping skills that don't have anything to do with covering up with substances. Helps me talk about things in front of people without shutting down. I actually was a peer leader. I was the senior recovery advocate there. So I talked to the other women on the microphone and they really listened to me
Okay.
the way I talked to them. So
All right, so are you confident you're in a better place now?
yes, in my mind.
You're going to make more
And I have a
mature decisions that are in conformity with the law.
yes, sir. I have a job lined up, an actual job with, Social Security taken out and things like that.
Yes, ma'am.
I have a new home to go home to. I have good family support because they believe in me. So
All right. Okay. Well, anything else anybody wants to add?
Nothing to state, Your Honor.
I'm going to find that the defendant has pleaded guilty voluntarily, knowingly, intelligently to allegation number 17, I believe it is, which is in the third amended motion to revoke probation, committing the offense of theft of property in Liberty County, Texas, of an amount over $30,000, but less than $150,000, occurring on or about March 21st, 2024. She has entered her plea of true voluntarily, knowingly, intelligently. That is enough to grant this third amended motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked. And this court has listened to the recommendations of the attorneys and as to punishment, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years for this state jail felony, punished though as though it was a third-degree felony because of your prior felony convictions that you pleaded true to at the time of sentencing. And the sentence shall run concurrently with other sentences. So, do you understand what has? Well, the only other thing is, let me dot all the i's.
And there was no
There any
restitution. Your Honor. No, sir.
Okay, that's why I take care of victims. Anything else? Do you understand what has happened today?
Yes, sir.
Fix this mess that you put yourself into. You obviously know better, and you have the tools to do better. So there's no excuse for failure. Failure is not an option with you. Be successful in your life. Can you?
I'm gonna give it my best shot.
No, you want to
Yes,
do
I
it.
can.
Everybody says, I'm going to try,
Well, I'm gonna
but
give
you've got to get over the bar. But the bar's set low enough, everybody can. You can too. Do it.
Well, she
Just do it.
No, I don't like it. It was horrible.
All right. Anything else? That is all. Thank you. Good luck, Nancy. Uh-oh, we need a thumbprint. All right. Please, in each case, please identify yourself and how you are related to the victim in this case.
My name is Sabrina Matthews, Wagner Matthews. I'm Isaiah's oldest sister.
That's Isaiah Wagner.
Isaiah Wagner.
Who was the deceased, who was
Yes.
killed in
Yes,
this case.
sister.
Okay, go ahead.
Sandra Matthews, the baby sister.
Okay. All right. You may go forward when you're ready. Thank you.
Isaiah Brandon Wagner, a gentle giant, was taken from us on January the 30th, 2022. Our parents' lives are not the same since that day. My mom is 84, 666 since that day. There's nothing we can do or say to her to make it any better. We wrap our arms around her and tell her I literally love her every day. Mama, it's going to be okay. Deep down inside, she doesn't think so. And she doesn't feel it. My dad is 84. Your parents and family and friends can go and visit you anytime they get ready. What we have to go and visit is a grave site of Isaiah. As one of Isaiah's oldest sisters, like I stated, we're a very close-knit family. All 5 of us. It was 3 boys and 2 girls. Our nieces and nephews, we're all like this. We come together in times of trouble and talk to each other and pray with each other, comfort each other, encourage each other. That's all we can do. He leaves behind 2 precious little children that between me and my sister and other family members help raise those children. Our husbands, they're here today to support us. They have helped in ways they didn't even ask for. But the love that they have for Isaiah's kids, that's what they do. That's what we all do. Jerry, my brother that's here today, you will always be our big brother, even though I'm the oldest. He's going to always be my big brother. It took us a long time, but not too long, to find out after Isaiah had passed, the grave site where the grass was growing at. It didn't take us that long to figure out it was him that was going out there cleaning that up. You took our loved one. I truly wake up some days in disbelief. I can't believe it. I touch it's real. He's gone. He's never coming back. I have a picture of him on my fireplace mantle. I pass by that fireplace mantle and I say, Isaiah, you don't even know what hit you that day. You hunted him down like an animal. For what reason? Oh, they said it was a girl. Oh, they said you disrespected me. How so? A human being. What happened to just talking? What happened to just get together? When I was growing up, it was just let's squash this. What happened to that? Take a life of another human and in that way. Coward, that's a coward. How could you? So disrespectful on so many levels. I feel mad, I feel angry. I'm sad for my parents, most of all. I can't even imagine. I have 3 girls. I can't even imagine them dying and getting killed, not dying just from a hospital stay or sickness. They had pneumonia and died. They had cancer and died. No. He was gunned down and shot and killed. Not one time. Kedron, not one time. You shot him 41 times on Grand Street. Get my numbers right here. You shot him 41 times on Grand Street. As if that wasn't enough, not 1 week later, 50 shots was fired, and then the gun was unloaded on him. You got 55 years for that. 55 years. He's gone. My parents are dead. They won't see it. If my mama makes it, probably with her health, and I'm not being funny. If she lasts another, I hope so, 10 years. The way her health is right now, God is my witness. I have no reason to lie. I'm sworn in here before oath. Who does that, I say? Who does something like that? But a person who just does not care for another human. Today, I found out how many times he was shot, 41 times. I said that. How are you able to look at yourself for what you did? You will never forget what you have done for the rest of your life. You have a long road ahead of you to think about what you've done. So I say all of this to say this. You are a soul that Jesus died for. I believe in there's a place after this life. I believe in God. God died for you, he died for me. Yeah, Isaiah made some mistakes. I'm not going to get up here and paint a picture of Isaiah, that Isaiah was all that and a bag of chips. I'm not going to do that. Isaiah made some mistakes. So have I. So have you. So I say this. You are a soul that Jesus died for. You need to repent. I am a soul and a child of God that Jesus loves, and I need to forgive you. So Kedron Perkins, I forgive you for what you did to my brother. May your soul rest in peace.
That's a check.
Hold on. Anything else? We are in recess. We are in recess on this case. Thank you.
Thank you. Judge, I've added on I've added on 2 defendants with murder charges that are going to be pleas.
Okay, thank you.
This is the first one. This is the first one. The second one's going to be Kedrain. Mr. Reynolds is working on that. Just keeping me in the loop about what's going on.
Javiante Fontenot, what are we going to do on that?
I have a motion to withdraw that.
Okay, that's 2 cases. Darren Patterson.
That we'd ask that, get a reset so I can try to get that settled, just
How long?
just a regular reset.
3 weeks is going to be good?
Next week's.
4 weeks good? Can we do 4?
We can.
All right. Darren Patterson, cause number 24, CR 110A, Mr. Burbank is the defense attorney, is requesting recess for 4 weeks in an attempt to resolve that. And Daniel Raleigh.
That's state's motion, Judge. It has something to do with
Okay.
the state's radio.
Okay.
Judge.
And here is Chelsea Ship. Does she need to be sworn in?
Already done.
All right, 22-40128 is called the state of Texas versus Chelsea Ann Marie Ship.
No.
That's you with Mr. Macon, your attorney and the state's attorney. Okay. This is a very serious case. They're all serious here. Some are more serious. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 26, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder with the use of a deadly weapon, namely a firearm, by shooting the complainant, the victim. Do you understand what you're charged with here?
Yes.
This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here now?
Yes, sir.
Is it because of the writing, Judge?
Yeah.
It's 40 years, Judge.
Okay, I'm gonna redo that, Jim. I know. I wish we had this pen for everybody. This pen seems to work better on the pad
Yes, sir.
than others.
Thank you.
And
Thank you for clarifying.
Okay. An agreement has been reached where you would be pleading guilty, sentenced to 40 years imprisonment. Is that your understanding of the agreement, ma'am? If I follow this agreement, you have no right of appeal of your case. Do you understand? You don't have, how do you plead to this indictment, charging you with this first degree felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with Mr. Macon, your attorney? Are the contents here true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer here. All of this is true. It states so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Is there anything else to add? I'm going to make findings now. If nothing further to add by anyone, I'm going to find that Ms. Ship, you are pleading guilty to this first degree felony of murder voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God, out of State's Exhibit 1, and the court supports those representations with positive findings that are in the record that state those admissions. I hereby find you guilty beyond a reasonable doubt of this first degree felony. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Anything else we need to add on it?
No,
Is there any,
no, Your Honor.
nothing else from
No, sir.
anyone else?
Not today.
All right. Do you understand what has happened today, now?
Yes, sir.
Okay. That is all. We are in recess on this case.
Thank you, Judge.
Take Mr. Peterson, take Mr. Patterson's file too.
Yes. If we fall through here, we'll go over the big hole, probably give it the.
Come forward, please. How do you pronounce your first name?
Michael Raven.
Okay, but it's two names though, right? So Michael and Raven, but it's Ravine, not Ravine. It's Raven.
Yes.
Okay.
Yes, sir.
Peterson.
Yes, sir.
All right. You were here with your attorney, Mr. Kimler, and the state's attorney. And your probation officer. Here in 23 CR 153, we've got two things here. In 153, there is a first amended motion to revoke probation. That was filed on April 22nd of a year ago. And then we've got a new indictment in 24 CR 530 of a third-degree felony of harassment of a public servant that was filed, handed up by the grand jury on March 6th of 2024. And my guess is that that first amended includes that new indictment. Yeah, allegation number 3 is out of these 8 allegations of wrongdoing here. Okay, so what today? Have a hearing?
Well, I'm sure the state, she's going to plead untrue to the offense, and I'm sure Mr. Boyd would want an opportunity to prove that up.
That's correct, Your Honor.
Are you ready? Do you have your people today?
No, sir. I saw that it was set just to announce that she was found competent. I guess that's what I was looking at.
Or we'd ask the court to revisit the issue of a bond on the. I know her mother is desperate to have loans. Probably been much into professional.
All right, I have a letter from Dr. Edgar Pond dated May 22nd, 2025, where the defendant was evaluated for competency, and the evaluation resulted in his determination that the defendant is competent to proceed to a resolution of her legal issues. I'm going to call this Court's Exhibit 1, today's date. 6/6/25. It is made a part of the record for all purposes, and we'll keep this in a sealed form. Any objection to its?
Without objection.
All right, is it made a part of the record for this case? The defendant, this motion to revoke probation began its journey on March 8th of 2024, when the defendant was alleged to have 5 violations of aggravated assault, resisting search, harassment of a public servant, all on February 13th, 2024 in Jefferson County, Texas, and failing to comply with program guidelines and rules of the Moral Recognition Therapy Program, which is good. It helps people make better decisions. And then failed to pay court assessed fees and was in arrears in her required payments for probation and other fees. Then a first amended motion to revoke probation came along April 22nd of 2024 and added allegations 6, 7, and 8. It is alleged that on March 19th, 2024, which would have been about a month, a little over a month after the first 5 allegations allegedly occurred, that she committed the offense of resisting arrest or search. March 19th of 2024 in Jefferson County, Texas, committing the offense of public intoxication on that date in Jefferson County, Texas, committing the offense of injury to a disabled person, also on that date. And the defendant is on deferred or unadjudicated probation for the third-degree felony of injury to a child or disabled person or elderly person, and it would be what? No, talking about which of those? Elderly person.
Yeah, yes or no.
So when can we have this hearing? As soon as possible.
We can have it within a week, Your Honor.
Okay.
It shall be done. All right. Huh? 17th or 18th? Y'all pick.
What day?
Today's 6th.
This 17th, I'd say.
That's gonna be week after next.
So Friday or Thursday?
It's a Wednesday. It looks like a Wednesday or
Tuesday and Wednesday.
Wednesday or Wednesday. All right, it's set for Wednesday, 17th? 18th? Okay, here is the order on the finding on Rapond. Dr. Rapond, that needs to be placed in the
Yeah.
seal envelope. And also 24CR, the new 530, the new indictment on harassment of a public servant that will roll with the motion to revoke probation.
You have
Do we have another probationer?
just that Ms. Bedron.
Yeah, that's just a review on her remaining balance of her restitution.
Who?
Denise, with drain. We go after.
Okay. What'd you say? We already did that.
No, we did one.
Okay, Denise Vitrine, that's you. 10-10405 is called. You're Miss Vitrine, and do you have an attorney still or no? Okay, you have, there's this motion to revoke probation that's been pending since June, 3 years now, 2022, which was all about restitution. And there's a lot of money here. You were sentenced to 10 years in prison, probated for 10 years for theft. A motion to revoke probation was filed prior to the completion of your probation. That has been pending, and that tolls or keeps the probation open. And we do that in cases where people still have restitution owed. And in this case, as of May in 2022, you were owing $212,415 to the complainant in this matter, physician. And so that's what we do. From time to time, we come back and update the status on where you are to ensure that there's money being paid as ordered. The court's very sensitive to victims. I think every court ought to be sensitive to victims, but I want to make sure that they're placed as close to whole as they were before they were victimized. So where are we on our loss here now?
Since,
What did it start with? How much? Well, I want to get a basis line here. On the probation order, it was $265,137. And then it had been, looks like 40 some odd thousand had been paid back over the 10 years.
like $75,860.
Is that right?
That's $75,860.
What's the balance now?
The balance right now is $197,640.60.
A little over $197,000. How much are you paying a month?
$50.
And then he's trying to get it too, so she's got that all right.
So what's probation office say? Anything we need to change on this?
So, I'm still watching it since, or
Our last review was, she had paid out $3,312 since November. Our last, since our last.
Yeah, but she pays 550 a month. Okay. So that's, but, that's. Well.
It's all restitution to restitution.
Ends up being about
To do something.
$5,000, $6,000
Every year.
per year. Which means at this rate, you only have 33 years to go. Okay. Right now, in your financial status, is this the best you can pay?
Very best. Yes, sir.
Okay. Well, it's better than nothing here. Anything, other things we need to tinker with on this probation? She's not reporting probably anymore, right?
And she's, I see her every other month.
Every other month, it's kind of just to check in to make sure that the restitution is being paid. Well, that's what boils down to the most important thing. So you were ordered, as all people are in this situation, to pay what you can. And the goal is to satisfy the restitution as ordered as quick as possible. But I think we all agree in this, understand in this case, it's going to take a while.
Yes, sir.
But keep plugging away. You get closer to the end. Anything else to add by the state?
No, Your Honor.
Okay. All right. From probation? Okay. Let's see here. Was it 6 months?
We supposed to be back here last month, but case moved to that.
Okay. Let's see her back in December, first part of December. Okay.
Yes.
Thank you. Please get a resetting. Anything else? No, we are in recess. Thank you.